Well, consular process is basically the term that we use for a family petition in this instance most of the time, or a immigrant petition to enter the United States. Usually, it's something that it's um, considered a family petition. So if you're petitioning for your wife, your child, or your parent, and they are outside of the country in their native country, and you're trying to bring them in as a resident of the United States, that is what consular processing is. So it's the process of bringing in an immigrant to the United States. They are actually immigrating to the United States. Well, the requirements for consular processing are very simple. We'll talk about it in terms of family petitions because that's what we do here at Virguez Law. So, basically, the requirements for a consular processing is basically you need a petitionary, which is the person that is going to be petitioning for what we call the beneficiary. So the person that's immigrating to the United States that's eventually going to get a green card is what we call a beneficiary. So that's the basic requirement. You have to have a valid relationship between a petitionary and a beneficiary. So let's talk about it in an example. Let's say that you are married and your spouse lives in Colombia, okay, and you're a United States citizen. So the requirement is you have to have some kind of status to be able to petition for your spouse. So you have to be either a citizen or a resident. In this case, if I'm a citizen, I have that requirement. The second requirement is that that person is you have to have a legally binding relationship. In this case, you have to be civilly married. So if I'm married to this person and they're a native of another country, I have all the requirements to be able to do a consular processing. So consular processing is what we call the process when the person is outside of the United States. Okay, and the reason it's called this is because you have to go through the U.S. consulate of your country, mostly in your country. So most countries have their own U.S. consulate, not all of them. One example right now is Venezuela. Venezuela doesn't have a U.S. consulate, so if you're a Venezuelan national, you would have to do it through a consulate in Colombia, Peru, or other neighboring countries. But yes, in order for it to be consular processing, you have to do it outside of the United States. Now, let me be clear though, you can be the petitioner, you can be the person petitioning for your loved one, and you can be inside the United States, okay? So you do all your paperwork through your attorney here out of the comfort of your own home. But eventually, once everything gets approved, your loved one's going to have a interview in the U.S. consulate of their country. So, who is required to do consular processing? Well, if your loved one, parent, child, spouse, and sibling lives outside of the country, they're all going to be required to do consular processing. However, what if your loved one lives here? Well, there's a lot of people that live here that have to go back to their country to do consular processing. And these are the people that did not come in with inspection for most part. So, an example, let's say that you're petitioning from your spouse for your spouse, and your spouse is from Mexico, but your spouse came iwi without inspection to the United States. They're gonna have to go back to Mexico to get their paperwork done. So this is kind of like, I guess you can call it a penalty that immigration put in place for people that came in without inspection. So if you came in without inspection, you're not covered for certain. You're not covered under certain exceptions of the law that we're not going to cover here. You might have to do consular processing. Very important that you talk to an attorney and have an attorney with experience handle this for you. Another group of people that might have to do it, do consular processing outside of the United States, is people that might come in within visa, right? But their relationship with the petitioner is not strong enough. It's not an immediate relative. So let's say that you came in with inspection to the United States with a visa, but your spouse is only a resident. So if your spouse is a resident and they're not considered immediate relatives, you're going to have to go back to your country and do consular processing. You wouldn't qualify for what we call adjustment of status. So adjustment of status is the people that can get their paperwork done inside the United States. So usually, if you came in without inspection, or your petitioner is not an immediate relative, and immediate relatives in this case are United States citizen spouses, United States citizen parents petitioning for children under 21, and United States citizen sons or daughters over the age of 21 petitioning for parents. If you don't fall under those three relationships, you're more than likely going to have to do a consular processing unless you fall within the an exception in the law that we can talk about in another live. So consular processing usually starts after the I-130 petition. Okay, once your I-130, which is your first, think about it as your first block in the immigration process. Once that gets approved, the I-130 is going to be submitted to what we call the National Visa Center. So the National Visa Center is the body of immigration that handles all the applications outside the United States. So you can think about it like consular processing starts once I have my I-130 approved, and that approval gets sent to the National Visa Center. So obviously, the benefit of consular processing is if you qualify for consular processing, what that means is you have the opportunity to become a permanent resident of the United States. So the benefit of consular processing is that if you do all your paperwork correct, if you have the right relationship, and you avoid any things that make you inadmissible, you'll be able to become a resident of the United States. Okay, so if you came in EWI, what we call without inspection to the United States, can you go outside of the country and do consular processing? The answer is it depends, right? So it all depends if you have certain factors that would help your case. If you have a bad criminal record, if you have a felony, don't you even think about leaving the United States. You're not going to get your consular process approved. If you came into the United States without inspection one time and you accrued what we call unlawful presence, let's say you were here for a year without being allowed to be here, and you go back to your country, you come back a second time EWI without inspection, you're going to have what we call a permanent bar. So outside of things of that nature, criminal records, misrepresentations, permanent bars, you will be able to do consular processing, and you should have a very successful rate of approval. Okay, the best thing you can do is hire an attorney or law firm that does these regularly. If you have an attorney that does this on a regular basis, your chances of approval are extremely high, because an attorney with this kind of experience is going to know exactly what to do to have your waiver approved if you need a waiver, or just knows how to navigate in your case through that particular consulate. So, if you're in the process of consular processing right now and you want to come into the United States and apply for a tourist visa or use your tourist visa, you can do it, but tread carefully, because if you have a tourist visa, that doesn't, it's up to the person in customs to let you in or not. When you have a tourist visa, you have a tourist visa and it got approved because you were able to show that you had no intent to immigrate to the United States. So anytime that you're coming in through customs, they had to admit you. And if they look through your record and they see that you're trying to immigrate, they can invalidate your visa. Okay. So it's a risk. Okay. So if you're going to do consular processing as an attorney, I would recommend that you do not try to come into the country with a tourist visa unless you're willing to lose it, because there's a good chance that you can lose it if the officer at customs decides that you have violated your non-immigrant intent. Okay. When it comes to applying for a tourist visa, you can do it. There's a good chance it won't get approved once they see that you have an I-130 in process or approved and you have a case through the National Visa Center. Like I like to tell my clients, right? A tourist visa is not a right. It's a gift and a luxury. And the U.S. Custom officer does not have to leave you, doesn't have to let you come into the country if they do not feel like they should.